It's taken ages. Properly taking ages. What's going on?
My YouTube showing as a 4 minute, 17-second timer. I don't know if that's any
So I
help.
know I just got like stuck. Hey, you right, everyone? I'm not sure if you can hear me yet, but well, it's better. I've got ticks and boxes here. Yeah, welcome everyone. If let's see if we're actually up and running. Let's turn that off as well. Cool. We all muted on YouTube. I think we have. Yeah, cool. Hope you guys have had a right week. What do we do? Yeah, right. So no personal data in the chat, please, guys. So just put questions as if they are about a hypothetical person. So, hey, right, Zoe. So just say, what if someone had damp and mold? What would the law be? Something like that. That's a great question. Makes it easy for everyone. Also means you don't put your personal data all over the internet. So that'd be awesome. It's not legal advice, as always. We're just trying our best to be helpful. If you're new here, the way this works is we'll go through any questions that have come in on the channel during the week. We'll start with the anonymized ones. So we'll do them first. Then we'll get to the live stream. If there are questions in the live stream that have personal data in them, I will delete them. Not trying to be horrible, but that's just how it is. So please just rephrase them to be anonymous. And then we'll go back to the ones from the week which are not anonymized. So I'm hoping to incentivize anonymizing questions, basically. And I've got a bit of gossip actually this week. So I don't know if anyone's on those Facebook groups, like the housing advice facing Facebook groups, where the admins have got high blood pressure, and every time someone says, "How long will it be till I get housed?" and they get really angry at them. So I thought, you know what? Let's just do an FOI to every council and see what average waiting times are. Started on Monday. I sent a batch off A's and B's to see if the question made sense, and I've actually already got some responses back. So there's about 300 and something councils in the country, and these are the results I've had on Thursday. So can you see that little Excel sheet? Yeah. So we've got Ashford. So this is all in days. So this is let me explain what this is, because it's got these are average waiting times in days for homeless households. So it's not just for the general housing register. It's very difficult to really work out useful average times there, because people can be on the housing register for years and not bid, and they kind of stay on the register. So it's not a very helpful way of doing it. But for people who are owed the main housing duty, these are the average ones we've got so far. Let me see if we can zoom in a bit as well. Is it going to let me zoom in? Yeah, it's cool. So Ashford, you got obviously got ones. I put 5 bed in there to see if anyone's actually got 5 beds. In Bedford, there's a 6 bed I came across once, but anyway. So 312 in Ashford, Kent. So reasonably close to London. So nearly a year for 1 and 2 beds, 2 years or so for 3 beds, and just less than a year for 4 beds. I mean, I don't read it all out. So far, obviously, North West is lowest, so 78 days average for 1 bed. This will almost certainly be once the final decision's been made. So this doesn't count, I don't think, the initial 2 or 3 months you're going to spend in temporary accommodation or interim accommodation until the decision's made. But as I say, I'm going to keep populating this every week. And just try and get a pretty comprehensive figures for people, because obviously there's lots of reasons why you want to know this. There's going to be times where, let me just unshare this for a minute. There's going to be times where you can actually apply to multiple local authorities because you've got local connection to multiple local authorities, or you're fleeing domestic abuse, so it doesn't matter. And so one of the things I'd say you should be considering is, what's the average waiting times in that council? Because if it's between applying to Blackburn and applying to Hillingdon, you can guarantee that Blackburn you're going to get housed in your lifetime. So yeah, that's just something I've been working on. And then LJ decisions from this week. Birmingham got stung twice more for B&Bs, families in B&Bs for more than 6 weeks. One of them was a year, so there's like £7,800 compensation for them. And there was a couple of other interesting cases, which I'm going to try my best to share the relevant bits here. So I'm just going to highlight a couple of little bits here and there. You can obviously go read them yourself. So this is, if I just put up the code, there's the code. This one's Birmingham. Nothing that flashy about this one, other than the fact it's £7,800. Birmingham had already made a payment of 3,600, but LJ said it should be more. Then there's this one here, which is Northamptonshire, which is my neighbouring borough. I've dealt with them before. Doesn't seem like they've learned any lessons. And just basically, again, it's an interesting case because there's no actual kind of clear idea of whether he was in priority need or not, but the council still delayed for a year. And there's what was it? There's a bit. So there's a bit here. So the letter contained inaccurate information about Mr. Let me just highlight so you can see it. Yeah, so the letter contained inaccurate information about Mr. B's eviction date. It said it was September 2023 rather than May 2023. Again, this appears to be a tactic to disguise how long it has been since Mr. B approached the council as homeless. So I read the whole thing, so I'm assuming there were other signs that the council were basically cheating or kind of misleading the records to make it look like they weren't as bad as they actually were. So there's that one there. This one here is Lambeth. Why did I pick up on this one?
You just going back to the
yeah,
previous one really quickly.
yeah.
Like, and I get the LG SCO can only make decisions on certain things. At what point is like fraud and purposely no, but like purposely changing someone's documents and their information? Like, at what point is that criminal?
Yeah,
Or like, at
so I
least
don't. It's
if
not
it
saying that they. Sorry,
gone,
it's not saying they changed the date. So it's just in the records they would have. So they didn't change it. They just. I don't know. I think that they would be very difficult to pin it on them and say it was definitely deliberate. So the LGO is saying on the balance of probabilities, yeah, that's probably a tactic, but they're not saying beyond all reasonable doubt it is. And I don't.
okay.
Essentially, I think what the LGO does is it puts this stuff out there, and then if the residents of North Northamptonshire wanted to hold their council to account, then this would be
Yeah.
a good thing to home in on. So
I can imagine it going the other way where you've got a client who's arguably innocently accidentally got a date wrong and the council's like, oh, you're trying to get housing, illegally or what have you. And I just think, well, this is obviously, yeah, fair enough.
well,
I'll shut up
so
and let you
so
go on to this
Shannon,
one now. Sorry.
yeah, no, me and you know somebody who worked in North Northamptonshire, having worked around 20 different councils, and they said it was the worst council they've ever been in. So yeah,
Yeah.
there's clearly some things which ain't too good there at the minute. Um, that's the North Northamptonshire one. Here is the one. It's Lambeth. I think the reason I highlighted was it's about kind of suitability of temporary accommodation. There's obviously a strand of domestic abuse in there as well. So I'm not going to go for any detail. I didn't actually read it, but basically there seems to be some good stuff in there that would cover a lot of the questions we often get in this live stream about kind of councils putting people in unsuitable TA. So yeah, you saw the code there for Lambeth, and so it looks like she got quite a lot of money in total. I can't see the actual total there, but something like 3 or 4 thousand, which is quite good for LGO. And then finally, what's this one here? Tower Hamlets. Why did I put this one in? Forgotten. There's something about it. I think it's just pretty standard gatekeeping actually. So yeah, so just again, if you want to see a typical gatekeeping case, that's a good one. Yeah. So anyway, that's the gossip. You guys got any gossip at all from the week? Will's live stream on his channel on Monday is up and running. Tech's getting smoother. So if you guys haven't already subscribed to Will's channel, get on it now. And yeah, basically same thing, but on a Monday, and Will hosting rather than me. But the aim's the same really. So just about kind of answering questions as they come up. But yeah, any you guys got anything to say?
I was on a podcast.
So I shared it
Oh,
last week, Shannon. Yeah, no, but talk about it
oh,
again.
okay, cool. So,
No, don't do it again. It's cool. It was good.
that's all right. Yeah, sorry for not being here last week. Yeah, so it was me and a housing officer talking about what it's like to access housing options through a local authority and sort of the gatekeeping that goes along that and sort of solutions and everything else. So
Do you want to find the link again? Because I put it in the link in the live chat last week. But if you can dig it out, stick it
yes.
in there. That'd be awesome.
Yeah.
Hey, what Layla? You what Cheeseface? You what Ava? Um, so and yeah, anyone else want to say it, or should we get on with the questions? You guys all right? So yeah, let's go to the questions from the week then. There was this collapse that for a minute. So question one from the week. This came from you through you, Shannon, actually. So I'm not sure if there's any backstory here. So topic of councils like Oxford sending people to hotels outside Oxford came up. We're talking placements tens of miles or hundreds of miles away. As part of this exercise, they lose the local connection. Is there any case law requiring councils to ignore this loss because they created it in the first place? Now, I don't know that you don't lose local connection by being placed in a different district by the council. So if you approach Bedford Borough Council and they place you in Milton Keynes and you're there for more than 2 years, you still have local connection to Bedford. So yeah, Chandler, have you got any more on this one?
Yeah, so just in this meeting this person was in, there was several different areas and locations there, and they were all saying the same thing, that like they all lose local connection. I wasn't in the meeting, otherwise I'd have said no, they don't. But yeah, so I was speaking to someone and they were like, well, can you put it forward? Because also if there's like which legal bit is it, and like is there any sort of extra case law that really backs this up? Because
Yeah,
everyone around the room, and including professionals, like just really accepted this,
yeah.
which is a bit disheartening. But yeah.
Yeah, without being too catty, I know a couple of organisations in Oxford, and I don't know that I trust them to push back on the council. But yeah, so I mean, basically, from the legal point of view, let me zoom in a little bit on this actually. So, from a legal point of view, assuming you've got local connection to Oxford City, let's say, so you've got it already, you make a homeless application, they place, let's say, they place an interim accommodation immediately, they then spend maybe a couple of days at most establishing that you are in fact homeless and you are in fact eligible for assistance, and now the relief duty starts. They then have to make a decision about your final duty within, well, basically day 57 from that point. So and that's when they will be saying, yes, you've got priority need, yes, you're homeless, yes, you've got local connection, or we're not shooting, or one of the other kind of exemptions apply, you're not intentionally homeless. And so the decision's been made then, and then Oxford City Council would have that duty to provide longer term housing. So they might still house them in temporary accommodation in another district for some period of time. But that it's a bit like the question that keeps coming up with Tower Hamlets and Walden Forest. The duty would be on the first local authority that's placed someone in a different district. It doesn't then become their kind of duty because they've been placed there. Otherwise, if you think about it, every council would place everyone somewhere else just to get rid of people, and it just doesn't work like that. So the only way that even, I mean, it wouldn't happen anyway, but you'd have to be placed outside of Oxford City for, well, either more than 6 months or more than 2 years mathematically to lose that kind of 6 out of the last 12 months or 3 out of the last 5 years. So that's not going to happen either. So yeah, I think the professionals in Oxford need to get a textbook and read it up basically. Anyone want to add anything to that, or is that? I mean, I think that's the answer. You got Karis.
Yeah, it is the answer, but instead of referring to case law, which they asked, it's referring to the Homeless Code of Guidance, Chapter 10, which,
Mm.
yeah.
Yeah. I mean, so if I get time now, I would dig around and see if there's any kind of knockout bits. But it's not. It's not. Yeah, it's kind of bizarre how they've kind of arrived at that sort of understanding. It's just yeah. I've not seen it before. Basically, I've not seen councils try and say that before. Will, did you have anything to add to that one?
Well, yeah, I mean, sorry if you said this, but the whole point with the homeless application is that it crystallizes at the date of the application. So if you had a local connection at the date of the application, you've got a local connection. You can't lose the local connection because they have to say, well, what was your status when you applied? I've had this in the past, not for a long time, but believe it or not, I think there was a case where the council took a long time to process the application. And during that time, a child turned 18. And then they said, oh, you're not in priority need now. And they said, well, yeah, you are, because she is, because the child was under 18 at the time of the application. And it's clear that you can't benefit from your own wrongdoing and delay it. So that's the same thing with local connection there, isn't it? Although, without making it more complicated, we have this every week, that local connection can mean something different for Part 6. So it could cause problems for Part 6, couldn't it? Because you'd have to have been there. I had this with Ealing. They did this. They put somebody who'd lived in Ealing all their lives, and they housed them in a neighbouring borough in temporary. And Ealing's allocation policy really does say you've got to have been here for 5 out of the last 5 years consecutive. So the minute you go out, including in accommodation they provided, you lose your local You lose the local connection for housing register purposes, not for a duty. But you couldn't go on a housing register.
Because I was going to say, so basically, if you're owed a duty, whether it's prevention, relief, or main duty, you are guaranteed to get on the housing register by having reasonable preference. So you might get a low banding, but you'd have to be on the register.
Yeah, sorry, maybe that was it. They I can't remember that. I mean, it was either that they were able to say they weren't eligible, which
Or
or that they just got such a low status that they might as well have not been on
yeah,
the
it was a good,
list.
yeah.
Yeah. Whereas if
Yeah.
they'd been in the borough, they'd have been on much higher.
Yeah, I mean, yeah.
The
I
other
don't know
thing,
who's in Ealing to kind of fight that sort of thing because it needs fighting.
sorry,
Members of
the
the
other
public.
thing, I'll keep my contribution as short as I can, but it does apply with children's services, and this is really annoying. So if you get to the stage where they find you intentionally homeless or whatever, and they say they've discharged their duty to you, and you need to ask for assistance from children's services, then if they've put you in a different borough, they will say, "Oh no, we don't have to help you. You're in a different borough now," and the borough that they're in um, will get very angry about it, and often at first point say, "No, go back to them. You're their responsibility." But the law, wherever it is, I've forgotten whether it's in the Children Act. I think the definition is within that if they are present in the borough.
Yeah, residing in the borough. I think
Yeah.
same for adult
It doesn't even have
services.
to, because I had a case years ago where there was a family that had been placed in Lambeth by Kensington and Chelsea, and the kids attended school in Wandsworth. And so we ended up judicially reviewing all three councils because they were all passing the parcel to the other one. And it turned out that you can have a look, the children's services can owe a duty, more than one authority can owe a duty, because if the children are in school, then they're present in the borough. And if they live in another borough, then they're present in that borough.
Okay.
But for homelessness law, it doesn't apply until then.
Yeah. Okay. Well, I think in terms of kind of giving some pragmatic stuff to go back to the individual, like we'll have a dig around in the code of guidance and if there's any kind of knockout bits. But basically, I mean, all I'd say is as soon as you have a person that's what the council's saying, just challenge it, and that's might be the easiest way to kind of actually pin it down and get them to change their tune. So yeah. Next question. I'll keep this is quite a long situation, but it came through our Facebook group today, and I thought it's not, I don't know the answer basically, but I'll see if you guys do. So, family's flat has had infestation of bed bugs. So those kind of all the household members were getting lots of bites. Obviously having a big impact on their well-being. Initially, council housed temporarily, so they basically made a homeless application to the council and said, it's not reasonable to be here, and the council accepted that and put them in interim accommodation. Got the pest control to go in there. They did one course of the fumigation, which the guy who was fumigating was saying this ain't enough. It needs like three goes or whatever. So they moved back in. The neighbours haven't been fumigated, and it came from the neighbours in the first place. So the bed bugs reappeared very quickly. And now the council is saying that we're not going to provide temporary accommodation unless it's like life or death, which, yeah, they're kind of inventing kind of thresholds. So questions are, what options does the client have in terms of being forced to return to her flat after they've sprayed it one more time, but still haven't done the other two properties, so it will just be backwards and forwards in and out. Even if they can convince LA to do this, what else can they do? So I know very little about this kind of scenario at all, but I know that the housing ombudsman, which is different from the local government ombudsman, has done stuff on this, and they're essentially the kind of they're the ones you want to go to. Obviously, you've got to exhaust the housing association's complaints first, but I'm pretty sure I'm sure a long time ago I read housing ombudsman decisions about bed bug kind of things, and kind of they offer compensation stuff. So yeah, and I've got a couple of bits I kind of add into this. So with housing associations, you can obviously complain to the chief exec is a sensible way of doing it, but there'll also be a board, like there'll be a chair of the board, and I would also maybe investigate who they are and send the complaint or copy the complaint into them as well, because they tend to be like the great and the good, kind of business leaders and stuff like that have been kind of retired and kind of brought into it, and they would probably be more likely to actually care, because yeah, I don't know. I think housing associations and general landlords kind of just get blasé about it. So yeah, that would be my contribution. But do you guys know anything more than I do about this one? Your muted faces doesn't fill me with confidence.
So I don't, but my only thought is like, I wonder if it's going to be easier or harder if because just because they're in one flat, it doesn't mean the next flat is the same type of landlord even. So they could be in social housing and the next door neighbour could be in private, or vice versa, or what have you. So I think I don't know if that's easier or harder, because you'd probably still do the same thing. Do you know whether you'd contact the landlords association and the housing ombudsman, or whether you'd contact social housing? But how you'd find that out, because
I
obviously,
mean,
like,
yeah, I mean, environmental health, I guess, because I think that's part of the answer as well. But as I say, I don't actually know. But to go to environmental health, I guess they would have the ability to contact all the landlords, like identify the landlords and contact all the landlords involved. So as you say, you're right. Could be that one's private, one's social, but making sure that it's all kind of coordinated. So yeah, I think just yeah. I don't know enough about the treatment process. Sorry, go on, Shannon.
no, I know it's another really weird one. Let's say they contact environmental health and they've just been placed in TA, and depending on how bad the infestation of bed bugs is or was or is going to be, the council have a duty to protect your property, right? So
Yeah.
that includes your belongings that might be subject to bed bugs. And I'm really I'm pushing the creativity here.
Yeah, no. So yeah, so if you're
You
owed
can
any
add on
housing
extra
duty,
pressure to the local authority by saying, like, look, you're placing me in TA, but you also need to place all of my belongings in storage. So they're not going to
well,
be. I
yeah,
don't know enough about
yeah,
bed
no.
bugs.
I know, I like it. I like the train of thought. So the duty to protect property is owed, if I remember correctly, to anyone who has essentially made a homeless application and is eligible for assistance. So it doesn't matter whether you're under prevention or relief or main duty or whatever.
And they
So
can't do it themselves. They
yeah,
have to
and
not
they
be
need
able
to
to protect
yeah
their
they need
property
to not have
themselves.
the
Yeah.
but if you think how like difficult it is, if you haven't got a lot of money spare, every time you get a bed bugs, you've got to go and wash all your stuff at 60 degrees. You've got it's going to be money involved, so it's not difficult to imagine a situation where it's going to be difficult to actually do that. But yeah, you're right. I think I don't quite know how the council do it. They've got a duty to protect property. It doesn't say how they've got to do that, so I don't know. But it's interesting thought. Whether they under that duty they need to pay for more fumigation. I don't know. I'm not sure. But yeah, I think
So
I'm not sure if we kind of given a click. Sorry, Karis, go on.
and it's making a home unfit for human habitation. So they use that and talk to the environmental health. So not only do they have to do repairs, and if they're taking responsibility, they have to see that responsibility right the way through, not just go, we're done now. But as a council association, like they do with mold, they'll just paint over and be like, oh, we're done. This time we're done. And they'll just continue to do it. So they've just got to continue to go through the process and probably complain. But
yeah, and
try
I
and get
think
a solicitor involved if they're eligible.
I mean, and part of this question is like obviously the family are understandably like not wanting to go back in until the problem's actually sorted. But I'd say potentially at this point, if their property doesn't have bed bugs at the moment, then I'd say they probably need to move back in, even though they're probably right that the bed bugs will return. But I think it's difficult to kind of argue that with the council, because at that point in time it is reasonable to continue to occupy. It would be my guess. But again, don't know.
And they've taken their steps, but they might have a policy on bed bugs and infestations.
Yeah. I mean, the housing association probably has many policies about it. It's worth checking out.
Yeah.
So I'm just doing a bit of admin on the live chat. Just right. So guys, just remember, please don't put any personal data in the chat. That includes asking questions about your own situation. Just make the question about a hypothetical someone else, and then you'll get the same answer, but you don't have to share data. So yeah. Cool. Right. So have we got any more questions from the week that are anonymized? Oh yeah, this one here. Nice little interesting one. Thanks, Shannon. So can case law in Scotland and Wales be used in England, or would it be just persuasive and vice versa? So Will and Karis might correct me or add to this, but basically, so the housing law in Scotland is quite different from England and Wales, and there are actually differences between England and Wales as well. But basically, you can use cases, say like a case about, I mean, I'm trying to remember the name of it. There's an old case from the 80s in Scotland, which was about a young lady getting sexually exploited, and basically whether that meant she was in priority need, and she was in priority need, and that was then used in English courts. So there are certainly cases I think where you can use it as being helpful. It's probably not authoritative, but it's certainly kind of an indicator of what the law might be. But yeah, Will or Karis, do you want to add to that at all?
Please. Uh, Will, you can correct me, but it's kind of like a guidance, not case law, whereas case law in England is like, this is what's happened before, this is what will apply here, whereas Scotland and Wales will be used as guidance more than case law. It's like a
Yeah.
Yeah,
second
I
tier.
agree. I think that's
Yeah,
right.
cool. Okay, and I guess there'll be certain things. So Scotland doesn't have priority need anymore, so there's not going to be a lot of stuff around that that's going to be helpful in England. I mean, I've made the argument before. So in the Welsh Code of Practice, it says that people rough sleeping are likely to be in priority need, which is obvious. That should be obvious to anyone, but it's not. So I have kind of quoted that because essentially, as far as I can tell, they use the same case law of HOTAC and Paniotu and all that sort of thing. So yeah. Anyway. Cool. Right, let's get on to the live chat then, guys. There is one more question from the week, but it's not anonymous, so I'll do it last. Where are we up to? So yeah, again, guys, if you've asked questions like identifying yourself, I'm going to remove it, and then I'll ask it when it kind of comes back on. So here we go. This is a good example of an anonymized question. So it may well be about the situation, but it's kind of separate from it. So how long from the start date of when they put you into emergency accommodation should it legally take for them to come to a decision if they owe you the main duty? So, great question. There is a video on the channel which answers this question, but actually it's not technically right. I need to redo it. So basically, you make a homeless application, interim duty to accommodate the Section 108 duty, the duty to give you emergency accommodation happens immediately. And then the next inquiry the council should make is, are you actually homeless and are you actually eligible? So remember, there's two thresholds we're working at here. When you make an application, it's reasons to believe that you might be homeless. And then interim accommodation duty is that you might be homeless, you might be eligible and might be in priority needs. So once they've established that you hit that threshold, then the job is to work out, are you actually homeless and are you actually eligible? So that kicks off the relief duty, which can only or should only last for 56 days. And they should make that final decision on day 57. So if you search, let's just do it. Let's go there. So Homelessness Code of Guidance, because I quote this all the time, but regularly. So if we search for the term day 57, here we go. So 14.17. So this is the Homelessness Code of Guidance, which is the council's rule book. This is almost legally binding, technically not, but I don't want that. No, don't want a free trial, thanks. Right, I think we're all right. So yeah, so where the housing authority has the information it requires to make a decision as to whether the applicant is in priority need and became homeless unintentionally, it should be possible to notify the applicant on or around day 57. In cases where significant further investigations are required, it is recommended that housing authorities aim to complete their inquiries and notify the applicant of their decision within a maximum of 15 working days after the 56 days have passed. So maths wise, that's 11 weeks. But realistically, how complicated are these kind of questions? They're not that difficult, are they? So if there was like an outstanding diagnosis or something, and they were seeking information about someone's kind of ongoing health, that might be a situation. But if you've got kids, you're automatically in priority needs. It should be pretty straightforward, really. So yeah, I think that's answered the question. Yeah, that seems like it does the trick. So next question. My screen's all telling me about Adobe now. How does a DHP work and how does it work with universal credit housing? Let me just put it into chat, into the thing so you can see what I'm talking about. Yeah, so how does a DHP work and how does it work with universal credit housing element? Do you always need to move into a property to claim both DHP and UC, or is a tenancy agreement prior to moving in enough? So good question. So the two different things, and they're administered by two different organisations. So UC comes from the Department of Work and Pensions, DWP, and the DHP is going to be somewhere locked in the basement of the council. There'll be a little DHP worker who kind of makes these decisions. So the DHP is designed to do whatever it takes to get you housed. And so if for some reason you need that money before you move in because you need the money in rent in advance or deposit or something, then yeah, you don't have to move in to get it. But the DHP process is councils can be quite flexible how they use it. So I'm not sure how much kind of rules there are, like what they can and can't do or what they have to do. It's more about, when does it suit them to use it? So and they've got other actual budgets as well to kind of do the same sort of thing. That's not this DHP, but yeah. So I think the answer is I don't think so. I think there just needs to be a good reason for them to get a DHP through so that you're no longer homeless. Is probably my answer. Again, guys, if you want to correct me or add to that, feel free. Karis?
I'm sorry, I was just going to say it is means tested depending on your income and set amount of savings. They do refer to that as well.
Yeah. So it's kind of it's like it's where all else fails kind of fund. You know, if nothing else is there, then they'll consider a DHP. Shannon?
Yeah, my understanding is that it won't affect your UC housing element. So like UC won't take into account a DHP. So it shouldn't affect like your benefit levels or anything like that. And also it's sometimes worth asking UC, because they have discretionary pots. And if it's a new claim as well, sometimes with the housing element, they might be able to give you an advance. But again, it depends on your circumstances and it depends on your area and it depends on a lot of things. So it's worth, speaking to either your work coach or popping a message in your journal just to find out what's available. And on that note as well, lots of local areas have, as well as like discretionary housing payments, but they might have a local discretionary fund. Can't remember what Bedford's called now. Something like that.
There's loads.
So, yeah.
House of Industries, Arms Houses. There's loads. Yeah.
I think Bedford didn't even spend all of theirs last year, so it had to be like rolled over into this year's. But again, often those things, and it's worth checking, like obviously the sort of criteria, but those things might include like if you've moved and you need money or cost towards white goods or furniture or whatever it may be. So yeah, it's worth having a mooch around your local authority's website for those sorts of funding and grants.
Yeah, cool. So next one. Is there any kind of template letters for asking for a Part 6 offer? And if Person X main duty was accepted in 2013, are they under rules that no longer apply? If so, which laws? So 2013, so the Localism Act came in it was 2011. It might have come in 2012, actually. I don't know. Can't remember. But the Localism Act was a real kind of horrible bit of legislation, and that's the bit which kind of enabled, first of all, it enabled councils to use private rented accommodation as a discharge of their main duty, the main housing duty, and it also it opened up the idea of housing people hundreds of miles away. So let's just go through this methodically. So is there any kind of template letters for asking for a Part 6 offer? So generally speaking, in my experience anyway, if the council can give you a final accommodation offer, which is basically a private rented offer, they will do, because they'll always say, oh, we've got no social housing. So there are certain characteristics that people might have which would make them more likely to get social housing. So things like having a disability, like a mobility issue, because private rented accommodation tends to be less easy to get adaptations to be made. If you're a couple without children, you'll almost certainly get private rented because your incomes mean that it's more likely to be affordable for you. So in terms of a template letter asking for Part 6, I mean, the short answer is I don't know of any. And I don't know that asking for a Part 6 offer is necessarily, I mean, it's nothing to lose by doing it, I guess, but I don't know it's going to have any weight really, because generally councils will house people as they see fit for their purposes. They don't really care about really, what the preferences of the applicant will be. In general, that's my experience. There might be some exceptions to that, I don't know. So that's kind of my stab at an answer. Anyone else want to add anything to that, or kind of say anything more about that one?
Can I just add a tiny bit? I don't think there are any template letters, because I mean, you could just, I'm sorry, Cheeseface, if I'm being facetious, but you could just make an application via the website or send an email or something saying, I'd like to make an application. I don't think it has to be any particular sort of formulation of words. And I checked when I first saw your question come up, I did a Google, and the Localism Act came into effect on the 15th of November 2011, which means that there's no old law applying to the 2013 application. I think unless unless it was, I mean, they applied 2 years before, and you could argue that they were therefore under the old regime. But the problem is, no, I think you just have to make a Part 6 application. So yeah, I wouldn't add much to that.
But well, so no, but I think potentially, if I understand this correctly, so that they're owed the main duty, which so in fact let's go back a step. So this is all. So by the way, this is ridiculously complicated. It's ridiculous all over. So what I'm about to say seems like it's ridiculous, but it is actually what the law is. So technically, so that term Part 6 offer. No, in fact, I'm lying. It doesn't say final Part 6 offer. It just says Part 6. Ignore everything I just said there. So yeah, in terms of said once the main duty is owed, yeah, I'll go back to what I said originally. Basically, I don't think there is any way to really increase the chance of getting a Part 6 offer rather than getting a 12-month assured short tenancy. So let's just go back a step. Main housing duty can be discharged in one of two ways. One is an offer of accommodation, which is social housing through the housing register, and the other is an offer of 12-month assured short hold tenancy in the private rented sector. I think what I'm trying to say is whether you'll get which of those two you'll get will be about what suits the council, not what suits you. But as I say, there's nothing to lose by asking for Part 6, and you can make a case and kind of say, well, do you know what? Actually, I need it to be social housing because I've got a disability or I've got a particular need, which would mean that's the case. But what you can't really say is because I want to have longer term, more secure accommodation because pretty much everyone does. So it needs to be more than that to really have a shout at kind of getting anywhere. I think that's my answer. So if we finish on that one, next one, I think this might be a two-parter. So yeah, landlord tried to evict tenant. The court struck out. He has then made a second application. I think that's the landlord has made a second application. It struck out again, and now he has sent appeal. I think again that's the landlord sent the appeal. Will family get help or need to make new application? Council advice to stay until bailiff eviction. So, the council can be helpful at this point, but you can't make a homeless application until a valid Section 21 notice has been served, and it's then within 56 days of the notice expiring. That's when you become threatened with homelessness legally, and that's when you can then make a homeless application. But the guidance does advise councils to be more proactive in situations because this might be a situation the council can basically save themselves money down the line if they actually intervene properly now. So, but I don't think you'll. I mean, there might be like a council-funded worker in the courts, kind of that you might be able to get help from. I don't know, but I don't know that you can make an application at this point yet. And then the bit where it says a council advice to stay until bailiff eviction. So check out. There's a video on this on the YouTube channel, which is like, do I have advice to wait until the bailiffs come or something like that? If you just search for bailiffs on the channel, you'll find it. And in that video, I give some LGO cases where people got compensation where that was what the advice was. So it's not legal. It's just not legal to wait until the bailiff comes before the council will intervene and provide interim accommodation, assuming there's reasons to believe there might be in priority needs. So yeah, again, that's my answer. You guys want any other offers on that? That's solid? Is that all right? Yeah, I'm getting nods. Cool. Next question: can we speak more on personal housing plans and what to do and what not? There's a bit more to it. Hold on. Okay, so yeah, there are some more questions from this guy, but it's seems to be the kind of more self-contained question. So, I mean, personalised housing plan. In short, once the relief duty or the prevention duty starts, council should carry out an assessment to work out why the person is homeless or is about to become homeless, what sort of accommodation they need, and what support they might need, and then they should collaborate to make this personalised housing plan. And in it, I mean, I don't like them. Will's got more time for them than I do because I just think they're just a template waste of time. But if you can use it against the council potentially, but you're meant to agree on these reasonable steps, and the reasonable steps will almost certainly be go look for private rented and then some councils I hear are actually making out that people, they're basically ending the duty because they're saying people haven't cooperated with that reasonable step, which seems ridiculous, but that's what they're doing. So you kind of have to make it look like you're following the plan, even if it's ridiculous. So yeah, what to do? I mean, try and actually make the housing officer do their job and kind of actually come up with something which is actually personalised, not just a template. Is probably quite a good start. So I mean, the person's talking elsewhere here about employment, so that's important. That's going to have a big impact on options. So really, the personalised housing plan is supposed to be the information you need and the agreed plan to actually stop you being homeless. So I think, that's probably key, is to actually carve out time with the housing officer to say, look, I want to do this properly, can we actually sit down and do it? What not to do? A lot of the things in the housing plan, personalised housing plan, don't have any legal weight. So they might tell you, you need to go and look for supported accommodation, but if they owe you a duty, they owe you a duty. It's not, it's not going to be, you can't, you couldn't end the duty because you've not gone into a supported accommodation. That's just not a right. So I don't know. What else? Thoughts, guys? It's obviously quite an open question, which is not a bad thing, but I mean, it's something it'd be good to do a dedicated video on, I guess, at some point. But I've not got much to say about it. I just think it's a bit silly, really. Yeah.
I'll just echo your view that we should have. I think it is subject for a separate video. The 2017 Act, I think those drafting it, unless they were just being cynical and putting out something false, intended to create a situation where local authorities, having accepted a duty, would carry out a genuine assessment of the needs of the person and then try and match that with accommodation which they could assist them in obtaining. And that's what the personal housing plan should say. Now, I totally agree with you, Mike, and then I thought this when I first saw it when the Act came out, I thought this is just going to be a load of blur, because I knew there'd been a duty to provide advice and assistance for years, and that usually just ended up giving a list of landlords and then saying off you go, and that was your advice and assistance. And I still think there is case law that says that where the council says to, for instance, to somebody who's not in priority need and the relief duty expires and they say, sorry, we couldn't find anything, you could challenge that and go for either a Section 202 review of the personal housing plan or a judicial review of the housing needs assessment and say, you haven't considered my situation. And one of those things, strangely, there is a case, and I'll look into this, where the council got into trouble because as part of the personal housing plan or the assessment, they hadn't considered helping the person make a Part 6 application, which ideally they should be doing that, because all these questions about how do I get a Part 6 application, ask your housing officer, because as part of your needs assessment, they can look into your prospects of success in doing so. But sounds a bit naive, doesn't it, if I say that?
But no, it's important, because I think before you even get to that stage, like the council has a duty to provide advice. I can't remember what section of the Housing Act is, but it's like one of the ones before you get to Section 183, basically. And actually, that means that, as you say, when you go to a council, they should tell you that you can make an application. I remember I had a case where a family had been told they're intentionally homeless, and there was a very easy solution to it, which was just to get the adult son to apply instead. And the council didn't tell them that because they didn't want to. And and that was a failure. They should have given advice and assistance at that point, saying, well, if the son applies in his name, there'll be a duty to house the family again. So, Anyway, so as I say, we'll put that on our list of videos to do a dedicated video about and kind of go into more detail. Right, hold on.
And just with all things, just check what they've written down. Like it's a legal process. I don't know if someone said that and I've switched off, apologies, but just check what is in PHP. It doesn't have to be, just so I can have a copy of it. Can I take a photo of it or whatever it might be, just to check what you're agreeing to, essentially?
Yeah, and if you've got like a militant housing officer, sometimes it's quite good. I mean, because I've seen PHPs where there's like someone else's details in there, which is a data breach. And so I've certainly kind of used that fact that they've just done a data breach as kind of like a way of like, let's be reasonable now and don't try and shaft the client. So so number 9, my friend went into temporary accommodation, might receive full-time job. What impact would that have been placed into social housing? So social landlords like people with jobs. They did have a policy. Many councils had a policy not too long ago where they would basically prefer people with jobs, but that was found to be discriminatory because people with disabilities that are less likely to have jobs. But so I don't know that it would, unless it kind of takes you over the money threshold, which I'd imagine you're doing very well. Probably wouldn't be on this live stream, to be honest, if you're a millionaire. But yeah, I think I don't think it's necessarily going to have any negative impact on you getting social housing. But I guess when I say that, if you're earning too much, and actually it goes back to that idea of, because private rented accommodation is more expensive, the council will place you in there if they think you can afford it. So if you have like extra money going on, I guess that might make it more likely you'll get private rented. But that's, I'm speculating there quite a lot. But I don't. Yeah, the one thing you want to be aware of with being in temporary accommodation with a job is it will affect your housing benefit, and it's just a real kind of mess to kind of get the housing benefit department to actually consider what you're earning and kind of keep up to date. And I know that a lot of housing officers will tell you immediately, oh, you work and you can't claim housing benefit at all, and that's not true. The council has a duty to make any accommodation available to you that it does. It has to be affordable, so it has to take into account your income. So you might not get as much housing benefit, but you would still be able to get by. So you wouldn't be worse off for having a job if the council's following the law right. So yeah, anyone have any additional bits on that one? If not, we'll go to the next one. So question here. Where
Actually,
can my
sorry,
friend go?
just one
Go
small
on, Sean.
thing. Like,
Yeah.
because if you're trying to work out and you've got a job offer and you're trying to work out the effect it has on benefits, there's some really good benefit calculators out there. I think, is it Turn to Us? And I've blanked on all the other ones. But yeah, Turn to Us is quite a good benefit calculator, and like your local CAB, and just because it might be that actually you can sort of weigh up your options then, and like it's a tough time in it. Anyway, sorry, next question. Apologies.
No, that's all right. It's cool. So yeah, there's another question that follows on from that, which I think. I don't know. What have I? No, I haven't got mad. It's all right. So I'll just put this other second bit of the question into it. We're still on number 9 here, by the way. We've just gone back slightly. But this kind of, I think this is, if my friend has a full-time job, would he still be moved out of temporary accommodation? I'm hoping we've kind of answered that already there. So he would still be moved out of temporary. Yeah, the duties are owed to people irrespective of whether you're working or not. But your income will be relevant to kind of what you have to pay. As I say, social housing tends to have like a limit on how much you can earn. Like they'll only take people like on less than, I don't know, 50k or whatever, depends what part of the country you're in. But yeah, it doesn't change the fact the council has a duty. Same way as like owning your own house doesn't change the fact the council has a duty. So you might own your own house, but it's been burnt down, or you're at risk of abuse there or something. The council's duties are absolute. They're not just on if you don't own your own home. So yeah, number 10, where can my friend go for personalised advice, and do you guys have credentials whereby we can contact you guys? So I take by credentials you mean contact details there. So I don't know, Will. So what's Virgo Solicitors capacity like at the moment, Will? What's the?
Well, we're trying to build it up, and I'm hoping that we could announce or at least answer questions like this in the future, of saying yes, contact us and we'll try and help you. But at the moment, we don't have the operation in place yet. So I'd have to say that I mean, I am a solicitor and I can help with this type of thing. It's just that I don't have capacity to take on every case. And so if I said to people who put questions in here, how do I get personal advice? And I said, oh, contact me. I'd be misleading you. And I may not be able to help with every case because I have to sort of filter out the ones that I don't think I can justify getting involved in. But on my website, if you search William Flack blog, there's a list in the resources section. There's a list of solicitors who may be able to help. And if you're, I mean, people have been doing this. I mean, if you're resourceful, you can track me down as a solicitor and you can email me. If I can't help you, I can put you on the waiting list. So yes, I mean, you can find solicitors. I mean, if you Google solicitors. Maybe you've tried this, you'll find one. But the good thing is now you don't have to. I mean, if you don't mind not, I mean, maybe people think it's a good thing not to go into the office, but you can do all of this remotely now. And so you could instruct, if you're in Liverpool, and well, not a good example actually, because there are solicitors in Liverpool, but you know what I mean? If you're in the middle of nowhere and there's no solicitors, you could still instruct a solicitor in London if you can make contact. So I hope that helps.
Yeah. So, Will, I've just put your blog with the list of solicitors on there.
Thank you.
So yeah, I mean, I guess this is the problem. The reason we do a live stream at all is because there just isn't enough capacity out there. So we are trying to help where we can, but obviously some cases are going to require a lot more, a lot more expertise and a lot more hands-on stuff. So, but yeah, as Will says, hopefully there'll be a point at some point where we can, work between us to kind of take more cases on. But yeah, check out the list for the meantime and just be persistent and kind of keep ringing around until you find someone. And also, I mean, I guess the question is probably worth asking. Well, as a solicitor, when you kind of rushed off your feet, I guess it helps if someone just kind of puts the situation into a nice kind of short summary rather than kind of, speaking for half an hour and kind of going around the houses. It's probably helpful that you kind of work out, okay, what are the things I need help with? What are the kind of questions I've got? When you first speak to a solicitor or speak to a receptionist or whoever picks up the phone, so they can kind of get a gauge of, okay, yeah, we know what the problem is here, we can help out, or we can't help out, whatever. So right, where are we up to? Someone just made the point, I think, really, that knows someone who's on relief duty for over 2 years. Make a complaint about that, because even if it doesn't leave you without a roof over your head, there's still money to be kind of as compensation for the delay and the stress and the uncertainty that caused. So if you run through the council's complaints process, you'll get to the LGO. They will recommend compensation. There are also quite a few decisions that you can find on the LGO's website, which gives you an idea of how much money to ask for. Because we're not talking about thousands, we're talking about, at most, I'd have thought sort of 300 or 500 or something. I don't know. I've not got a conversation with someone just for that before. So yeah, but yeah, complain, because it's not acceptable. Councils, kind of breaching their duties like that. So next question. So my friend is a carer and child who is in a final year of secondary and one who just started. She got moved to 1 hour 30 away. Can the council do that? So there's statutory guidance on how far away you can be from your school, which is called school transport guidance or something imaginative like that. Let's see if I can find it. But basically, in that document, so it's a government document, and it basically says that secondary school age children need to be no more than 75 minutes from door to door. So it's not actually the bus journey or the train journey or whatever. It's how long it takes actually to get from your front door to the school's front door. So if any of you guys can find the guidance before I can shout, but I think I found it here. So yeah, here we go. So let me share it just so you can get a look at it, just to familiarize yourself with it. Here we go. So you guys see that all right? Then if I search for 75 minutes, so hopefully I'll find it. Here we go. So paragraph 98. As a general guide, the maximum journey time for a child of primary school age should be 45 minutes each way and 75 minutes each way for a child of secondary school age. So yeah, so basically, yeah, that's the document you go to. So now, again, Will and Karis, you might have experience of kind of running the argument in this sort of thing, because the other thing that's relevant here before I go there actually is the fact that if you're in your exam years, then there needs to be particular attention paid to this kind of thing. But yeah, I mean, do you guys want to just add anything in about this one? Sorry, I keep throwing it to the solicitors here because this is more your bag.
I could come in. I think the general rule of thumb is that if the children don't have exams coming up or are not in a critical year, then they can be expected to change school. That's difficult if it's temporary accommodation. But the problem is that councils will say, well, temporary accommodation could be, you could be there for a long time. We're not saying to you we're going to put you there for a week. But I was just looking at the case which I think the case which we've mentioned the most on this video is that Lambeth and YR case. I think that one of the reasons was the schools in there, and they hadn't looked into it. I mean, I think the simple answer to the question that's being asked here is the council can do it. The question is whether you can successfully challenge it. And I think you'd have to show that there was a particular need for your child to be at that school, and that would mean that the accommodation was unsuitable. Because there is a case called Southwark and Foku, where they held that the court refused to find the offer of accommodation unsuitable and said that the parents should consider changing schools. So it's not just that they go to that school. I mean, it's really unfortunate because it really is a very distressing thing for a 6-year-old to leave their primary school because they've made some really close friendships, and just to be yanked out of that is really harsh. And you can't just treat people like farmyard animals and say, oh well, you can go there, you haven't got any feelings. But unfortunately, they can get away with that. I mean, I suppose they just have to say there's different things, competing things here, and ideally we'd give you accommodation near the school. But if it's not essential for them to be at that school, then I think they can get away with it.
I mean, it's something just for those
Please
who aren't.
correct me. I'd love to be wrong on that.
You know, I think you're right. I mean, it's something for those guys who aren't currently homeless having to deal with all that stuff. If you want to go to your local housing committee and ask questions about this, we've done it at Bedford. We've said, you know, how does the council deal with school placements and making sure that that kind of that sort of continuity of education is not affected. And obviously, counsellors who are generally, you know, decent people, they're like, yeah, this is important. It's important that kids don't get disrupted in this way. So, but I don't know that that's going to help out in an individual case. It's more about kind of getting systemic change and kind of just raising it as an issue. Yeah, Shannon.
So I guess as well, some areas will have a local school transport policy. So it might be worth contacting your local school transport team to see if like arrangements can be made via that. And did you talk about the fact that they're a carer, or did I miss that or not?
I think it was a typo, but no, sorry, yeah.
Because obviously, if you're a carer, you're protected under the Equality Act. So I'm not saying they are discriminating against you, but potentially, actually, if your caring duties and responsibilities are in that local area and you're struggling to care for a person because of the location being moved, they do have to consider that under the Equality Act and stuff. So I'd probably make that point, and it might be an easier point or like a stronger point to make. Maybe is that
yeah. Okay. So Cheeseface, I'm going to ask that this is going to be really annoying, but if you could copy and paste the text of what you've said and stick it on any normal video on the YouTube channel, I will respond to you individually on the channel, like in kind of in writing, because I think I'm not sure how good this format is for kind of going into detail. So I'm really so I can get back to you tonight probably if I put my mind to it. So if you could just basically copy what we explained, because there's a lot of text obviously. If you just kind of put that onto like a normal video, and I'll get notification, and I'll kind of just come back to that one that way if that's okay. So I just think as I say, this is not the best format really for kind of going into the nitty gritty. But I'll try and get a response to you as soon as I can. So the next question I can see is this one here. So if the PHP isn't updated, should you request it to be updated? For example, if a new health sorry, I've done that twice. The answer is yes. I mean, I think I'm not quite sure what difference it would really make. I mean, the PHP doesn't really have a direct bearing on whether you owed the main duty or not, because that's all down to whether you're homeless eligible in priority needs and not intentionally homeless. But I think it will be relevant. I think whenever you've got health issues, you want to make sure you can prove you've told the council that you've got those health issues, because if you tell the council, look, I've developed a spinal issue and I now need a wheelchair, and then 3 months later they try and stick you in a 4th floor flat or something, then you can say, look, what are you talking about, guys? I told you already. So I think having it in writing is always a good thing. Whether it needs to be in the PHP or just an email where you're engaging with the housing officer and saying, this is important information. I think that's kind of the way I'd look at it. So anyone want to add anything to that one? If not, I think this is the final question I can see on the live stream for tonight. We've got one more from the week. It's a political one, so I don't know how we can do that. Do you know if the current political party is going to make homelessness processes easier or harder when it comes to duties? Everyone is hearsay, but I'm not sure what policies they're going to use. I've not heard anything really about the change in. I mean, obviously, the fact if they do end Section 21 notices, that will have a bearing on the homeless application process because the guidance will have to be changed. I don't know what they're going to replace it with yet, because I'm assuming they will replace it with something to allow landlords to get their properties back. So, but I've not heard anything at all that would affect the actual homeless application process. I mean, they're saying they're going to build more houses. We'll see. They're saying quite a lot of stuff, but I don't know whether that's going to happen or not. So yeah, I'm not. All I can say is I'm not aware of anything, and I would be very interested if they were looking to change anything, but I don't think they are, as far as I know. Again, any of you guys know anything more than I do, let me know.
The only sort of legal change I can think of, and it kind of isn't the current political party, but kind of is with the Supported Housing Act. So obviously that was passed by the previous government, but the Supported Housing Advisory Panel, which is coming up with the qualities and standards, will be recruited by the current government. So, and that will affect intentional homelessness decisions in regards to people being evicted or leaving supported accommodation, exempt supported accommodation in particular. So that's the only thing I could think of, if that makes any sense to the world.
Yeah. No, that's cool. I mean, yeah. I don't think the government knows what it's doing yet. So we'll see. So there's a couple more just going in the chat, but let me just do this one from the week. So what happens if I'm asthmatic and I've been offered a damp and moldy cold room, which they keep painting over? The builder tells me that if I'm asthmatic, I should not consider this room due to the history of the room. So, the builder's been trying to be helpful there, but unfortunately, you can't really quote him unless you're going to put that in writing. So, but the answer about damp and mold is if you have medical evidence that it's affecting your health, then you can make a homeless application. There's a case called Medina, which is on the Isle of Wight versus DEE, where essentially, in this case, a baby's breathing was been affected by damp and mold, and that made them homeless. So, so that's kind of the answer is make a homeless application. The worst thing that's going to happen is they put you over to environmental health, which can maybe do something. But yeah, I mean, and I think in a case where you've got damp and mold, take loads of pictures is something that really does speak volumes if you're getting pictures of stuff and sending it on to counsellors. So check out the video I did on the channel about how to make the best way to make a complaint. I think I called it from a few weeks ago, because I kind of talk about there about engaging with local politicians, and actually damp and mold is quite politically a thing at the moment. You've got the Awabishat case and the kind of stuff happening with the legislation at the moment on that. So I think, I think you need to wait for there to be an issue though. So I think if they just treat the damp and mold, you need to wait for it to become an issue again. Is sadly the way I think it's going to work, because you're going to need evidence of that. So take photos of it now when it's not got damp and mold on it, and then if in 3 weeks' time it has got damp and mold on it, you can say in only 3 weeks it's got really bad, and then you need to get a letter from your doctor or something which confirms your diagnosis of asthma and kind of just medical advice saying that this is not suitable. That's what happened in the Medina case. The doctor said it's not suitable for the baby, and that was basically the end of it. That was the end of the argument. So how you watch that in it? So just there's a clarification to that one about the updating the PHP. Just saying the main duty's already been accepted. So I guess what the housing officer's meaning by following the original PHP is they're saying continue to look for private rented accommodation. I'm not quite sure what else you can do at that stage, but yeah, no, keep them updated. Always keep them updated, because you never know when it's gonna matter. So yeah, it may not make any difference, but it's worth doing anyway. So one I don't have a foggiest idea about, but that's why there's 4 of us. So this one here, how long does it take to appeal a Section 13 rent increase? Over to you, Will or Karis, because me and Shannon are looking very blank.
Shall I dive in there?
Okay, yeah.
The simple answer is I don't know, and that's partly because I don't know quite what the question means. Does it mean is there a time limit to appeal, or how long does the appeal take to be considered? And presumably, if the appeal is to a tribunal, so I'll just check Section 13 rent increase. So that's I mean there's
There's a
quite
bit.
a lot
Hold on,
from
there's a bit.
Shelter.
Sorry, did you
Shelter
just
about
say that? So there's a bit more on this one. So let me just add this on, Will, before you continue, because it might have a bearing on it. So yeah, so can a rent increase tribunal agree to the landlord's rent increase approximately market rent, even if the property isn't in a marketable condition?
Yeah,
Yes.
I'm better at answering that one than the previous one
Yeah.
because I would have thought that if the property isn't in a marketable condition, it has no market value, there's no market rent, which seems absurd because presumably if the tenant's there and they're not sort of suffering incredible hardship as a result of the conditions there, then it is marketable. Doesn't you may not be able to get a very high rent for it. But sorry if I sound pedant, so I'm being silly about that. But I would have thought that yes, they can. I mean, well, it depends if they really said this property is so terrible, despite the fact that the tenant is living there, that you couldn't put it on the rental market, then presumably they wouldn't get a very high market rent for it, possibly zero. I'm sorry if that, but as for the time limit. I don't know. I
So
think you have a certain time from when you get the rent. If the landlord serves Section 13 notice saying I'm increasing the rent, and then I've forgotten how long you've got to actually challenge it.
I think Karis might have some stuff on this.
Oh, good.
sorry, sorry, but I think so. They have a month to notice to give you that they'll increase the rent, and you have to do it before they increase the rent. If that means how long do they have to appeal, and if they mean how long does it get that if you've appealed it, they can't increase the rent until your appeal's been heard. And I think that if they mean how long to get to the tribunal to be for their appeal to be heard, that's depending on your court system, wouldn't it?
So you could be looking at quite some time, effectively, because I think this question
Couple of
relates to
months.
someone who's probably going to be on the way out of this property anyway. So I don't I mean it might be that it just becomes an academic point. I don't know, because by the time it gets that far, it's not going to be relevant anymore. Is maybe something's going to happen. I mean, is there somewhere to find out more stuff about that? Because as I say, I've never come across it before at all. But is there like I mean, does shelter cover that sort of stuff, or is there like a good resource somewhere that kind of covers that sort of info?
In the
Or like,
There's stuff on the shelter website about it, and I mean I'm just googling it at the moment. So I think
and
the answer to the question, what's the time limit? If you are just talking about how long have you got? I mean, unless Karis did answer that, but I think that sort of question you can find if you look on Google.
okay,
it'll be a
cool.
number of weeks before they get to the tribunal.
Yeah. Okay. So there's still a couple more in the live stream, guys. If you need to go, it's past 8:30, so feel free. So my friend has been in private accommodation for 10 years, and council hasn't done anything to help. She's now getting evicted, hence why they have a temporary accommodation. What can she do? Can she do for council to help them? What can she do to get the council to help them? So okay, I'm reading this to say that the evictions, the person's already in temporary accommodation, is what I'm.
I
Okay,
think it may be the same friend who's been offered the temporary accommodation, which is a long way from the school
okay,
we
I
were
see.
talking about before. I'm guessing. I
Right,
mean, maybe
yeah,
Katie or Catty can confirm that.
yeah. I think so. If you're not, I think the real kind of big thing here is whenever it comes down to suitability of accommodation, is yeah. The ridiculous thing is you need to accept it and then challenge the kind of suitability of it. Now, the first instance, you can't really challenge the suitability of it unless you get a solicitor involved, if I'm right in understanding that. You can challenge it down the line. But yes, I think I think basically we'd have to say accept the accommodation. It's an hour and a half away. See if you can kind of get by in the short term. If you can't get a solicitor to go judicial review, then just get every kind of get the schools to write supporting letters. I've done that before; it's worked. Get local politicians involved. Children's services, housing, the MP. Bearing in mind the MP is actually the least powerful person in this situation. So your kind of councillors and kind of your portfolio holders for housing and for children's services are going to be important here. So I think that's kind of I think that's because the problem is if you refuse that accommodation, then it's going to get difficult. Like technically, children's services would have to step in, but they could offer you something 5 hours away, and there's no real kind of rules on what they can do. So I think that would be, if I'm understanding the situation correctly there, then that's what you need to do. Yeah. Okay, so that's it. I think that's all the questions done, guys. Come check us out on Monday on Will's channel, 7:30 again. Keep the questions coming in. There was something I wanted to ask you about actually. Can't remember what it was now. That was it. So I've got a question for people to think about, and if you want to put a comment into the channel, just let me know. So I'm doing a video about various things at the moment, doing some videos for the channel. What I'm really interested in is I do a lot of training for people, for professionals who they love it. They're like, this is amazing, this is great news. But then they really struggle to put it into practice because you've then got to go and take on a counsel and you've got to, put your head above the parapet. If anyone's got any kind of thoughts about how we could be more effective at empowering professionals to challenge bad practice, I'd really like to hear any suggestions because I'm out of suggestions basically. So I'll just leave that with you really. And we'll see you next week on this channel. And see you on Monday on Will's.
Sorry, can I say one thing before you? Which just to say, if anyone wants to join us on Monday, I've just put a link in the task. I've got the live stream for Monday is up, saying it's going to happen on Monday at 7:30. But if anyone wants to put questions in, you can do that from now. So if you go to that, you can either do a Google search for William Flack live stream, and that'll come up like it just did when I did it. Or you can click on that link if it's still around. But you can put a question in there and then we can come back to it. But as with Mike's point, please don't put it in the first person, what can I do about this? If just put it like, what can my friend do about it, or somebody I know, or a person even, and that's fine. So that's it. Thanks, Mike.
Yeah, that's cool. And so that's just for those as well. So the good thing about putting questions in advance is you're not limited to characters. So I know people here are having to put long questions across multiple posts. It's quite annoying. If you're putting those posts, if you're putting the questions in the comment section, or as Will said, as a post, then you're going to get you're going to get kind of it's more easy to kind of get the answer and get the question across. So yeah, cool. And thanks, Dee. I've just seen your suggestion. Cool, nice one, guys. See you next week. Let me just get out of this live stream.